and really reading this police report where
Had to
he
do.
thought someone was God, he stated she was God and he was God and the baby in her named Jesus.
Welcome to Bench Report Court Cam.
Zachary DK? Dyke. Okay. Come forward. Okay, see, here's another name. What I learned in elementary school was when two vowels go walking, the first one does the talking. No, in his name, the second one is talking. The first one is silent. So I'm going to remember it. Zachary Dyke.
Dyke.
Dyke. Okay.
Dyke.
Court is.
So I'm told.
Okay. Okay. My grandmother would always say that. She would always say, you just know this is the date you're born on because that's what I'm telling you, really. There's some things only your parent would know.
They told me you're from Louisiana.
Yes.
Is that right?
That's
Yes.
his
Where
friend,
at?
okay.
Where are you from?
My mom's from Arcadia.
Ah, okay. And I know you're telling the truth because you said it right.
All right.
Court is calling 2023 CR 5173 State versus Zachary Albert Dyke. Could I have the parties announced for the record? State.
Megan Galloway for the state.
Lorraine Ephraim for Mr. Dyke.
Are you Mr. Dyke?
Zachary Albert Dyke.
All right.
Dyke.
Counsel, have you received all discovery?
Yes.
Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there any applications?
No.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Your Honor. Wish to waive count 3 and proceed on counts 1 and 2.
Objection.
All right. So the way it's listed in the indictment that I have, it's paragraph A, B, and C. So is there a different indictment? This is what I have.
So
Oh, yeah, I don't think that.
that would be correct, Your Honor, because so we'll proceed on paragraphs A and B and waive paragraphs. But I will need to change that in the paper.
Okay. Well, does anyone have any objection to it being labeled as count 1, count 2, and count 3 in the indictment as opposed to A, B, and C?
No, not from the state.
No, Your Honor.
All right. So, state, are you moving to change paragraph A to count 1, paragraph B to count 2, and paragraph C to count 3?
Yes, Your Honor.
Any objection?
No.
All right, Mr. Dyke, what they're doing is they're just changing the label of each paragraph. Do you have any objection to that?
No.
They're
Your Honor.
not changing the substance of the indictment, just the way that it is numbered. All right. So, state, are you proceeding on the indictment as presented? Which counts are you waiving?
Your Honor, we are waiving count 3 and proceeding on counts 1 and 2.
Any objection?
No, Your Honor.
All right. That you review the document entitled Court Admonishments with your attorney. Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand? And count 1, you're charged with arson with intent to damage a habitation or place of worship.
Yes, Your
And
Honor.
in count 2, you're charged also with arson with intent to damage a habitat or place of worship.
Yes, Your Honor.
All right. Do you understand those are first-degree felonies?
Yes, Your Honor.
And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I accept the jury's verdict on that matter, Your Honor.
So you did have a jury trial?
Yes, we did.
All right.
But I do think he's competent.
Mr. Dyke, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 1 and 2. They are asking that your punishment be assessed at 8 years in the prison in both counts. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the document? I'm sorry, did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? I'm sorry.
Yes.
It's the waiver of appeal paragraph?
I believe so. Yes, Your Honor.
Well, let me show it to you.
Yes, it's no appeal.
Yes. All right. Did you understand that?
Yes.
All right. Did you understand by signing that you're waiving your right to appeal?
Yes, Your
The
Honor.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Well, there was a competency jury trial, a few things like that, but
All right.
other than that.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
Count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit number 1 and attachments.
No objection.
Did you review the document entitled Waiver and Consent to Stipulations with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Well, I understand what you're saying with the disagreements with that.
Yes. And to that end, I actually made a notation in the paperwork because it generally says you believe your client was legally sane at the time, and we're not urging that defense, but I wouldn't be, want to be saying that I couldn't urge it under different circumstances. That makes sense.
All right. Well, I don't step behind jury's verdicts. They're saying he was sane.
It was competent at the time.
Well, they're saying he's competent at the time.
Competent now. Sanity would be a trial defense.
Yeah.
And we're not urging that trial defense.
All right.
Does that make sense?
Yes. But I see that there, in really reading this police report, where he thought someone was God.
It had to do with medication, Your Honor.
Okay.
My medication got all messed up and I wasn't in my right state of mind at the time. And I know that 100%. At that time, I was not in my right state of mind. And whenever I came into the jail, I wasn't in my right state of mind either, because I've been in recovery for a long time and I was on maintenance meds, methadone, and I was detoxing off of those medications whenever I came in here. And I didn't have the right medications being in the thing, but I've been in here for 2 years now and I'm really level-headed now. But when I first came in here, I was not right.
There was an initial, well, let me put it this way. There was an initial finding of an agreed incompetent to stand trial.
Mhm.
Let me restate this. So the jury trial was on the issue of whether he had been restored to competency. And I contested that, much to my client's disagreement.
Mhm.
And the jury did find that he had been restored and that he was now competent. And so that's what put us back on your trial docket today. So it was pending quite a while he was in restoration posture.
All right. So here's my question, and I don't want to go behind anybody's agreements that they worked out. I normally don't do it, but I'm reading the police report.
I know.
And I know that sometimes that people are using drugs, and that's not a defense. I use drugs and I got bad drugs, so therefore I'm hallucinating. but I see that there are issues where who knows, maybe the behavior wouldn't have been what it was, because what I'm reading is he admits to it, and it says he stated that he set it up, that everything had been set up when Flores got pregnant. When asked who Flores was, he stated she was God and he was God, and the baby in her named Jesus. And then he said, I lit it up and it went up. And he's like, I think it was the table.
And Your
And
Honor,
this
sorry.
has been an ongoing setup, and they've been telling me fire and water. When asked what he used to light the fire, he said a lighter. When asked what he was thinking after he lit the fire, that was the old me. It's gone. Then it was a new me. That's what they're telling me, that the old me and I have to leave it all behind. So what was set on fire was a table, a chair, and a bed. So what is his criminal history?
Your Honor. Can I say one
Do
thing
you
real quick?
do you feel as though you're losing this argument?
No. I just
Then why
want to
you're
say,
adding?
I just want to
Then
say
you,
that
you may
there's,
not want to add. I'm trying to figure out certain things here. Yes.
I'm trying to help you.
Stop.
Yeah.
She didn't ask you.
But going to what the court has.
And mind you, I'm all for following agreements. I'm just trying to get to the bottom of, my determination is whether agreements are appropriate or not.
But I have taken into consideration the court's concerns as well, and that's something that we have conferred about alternatives, and we just wound up
Okay.
where we are. So regarding his criminal history, he does have so like a misdemeanor estate from 2007, UCW from 2017, a PG3 possession less than 28 grams from 2020, a resisting arrest from 2020, a possession PG1 less than a gram from 2017. The offense that we're here for today, a possession PG1 1 to 4 from 2017, a 4-200 possession PG1 from 2018, a possession of marijuana 5 to 50 pounds from 2020, and then PG3/4 above 28 grams from 2017. And sorry, that was out of order.
No.
And I think most of those did not result in convictions. Many were dismissed or otherwise resolved. So I think what would actually, I mean, I know you're just reading about arrests or bookings, but I think in terms of like what is actually in terms of conviction or
Nothing.
yeah.
So that would be correct. So he was only placed on deferred adjudication for a misdemeanor resisting.
All right.
He has almost 2 years credit pending incompetency restoration. So he's been in custody quite a while, which was another factor in our discussions today. And as far as I can ascertain, I don't see that this becomes a 3G in any way.
Okay.
I can't represent when he would get paroled, but just that he would have what it appears to be normal parole eligibility.
All right. And in
his I mean, there was a lot of contact during the pendency of the competency proceedings with the DA's office and the family, and we had a pretty intense trial on the issue.
all right. So what is this with regards to the complainant listed is Dike as well? Who is that?
Mom.
His mom.
Uh-huh.
And is she aware of this?
Judge, so I didn't reach out to her today. During the competency,
She testified.
did reach out, and I have correspondence from her where she's requesting treatment for the defendant. But like I said, that was explored, in our negotiations.
She did testify. I think I think as you can imagine, many parents would be, highly conflicted here. This was serious. She bought this for him, whether it was hers or his by gift, might be a dispute, but nevertheless, it was her funds that paid for it, and it's gone, destroyed to the ground. She's obviously loves her son, very concerned about him. And so I think she would be, she doesn't expect restitution. I think it was covered by insurance. I'm not sure.
There was no insurance claim on it, but it was
All right,
actually.
as I can say, this is what I'm saying. And I will follow your agreement. There's some times where I may think, this is very harsh. There may be some times where I think this is not harsh enough. And I'm just trying to discover, is this a prison case? Is it not a prison case? That's what I'm trying to get to the bottom to. Sometimes when people commit offenses, does it appear that you're losing this argument?
No, I just want to say
Okay.
a few things because you're saying that.
No, can you just wait, because she's
Okay.
the judge and she's speaking.
I understand.
All right,
You don't mind.
So sometimes there are reasons maybe why people do things. And then sometimes you have somebody, they're just a bad apple. This is just what they're going to do. As the attorney was in here saying that raccoons and other animals just come in and destroy chicken. Well, coyotes, I think he said, destroy chicken for no reason. Not hungry, just like, why not? So I'm struggling a little bit with this one because based upon what I'm reading, there's mental health issues. Maybe those mental health issues were drug induced. If that is, you got to stop using drugs. So if you all want, I will follow this agreement. State, I know you are asking me to follow this agreement. Do y'all want to discuss some more or?
I can discuss with Efron some more, but I do want the court to know.
Yes.
Your impressions are not lost on me. There are things that I did.
Okay.
Not saying that I'm going against you, but
No.
what we've talked about as well. But we can talk something.
Oh, and let me just tell you, go against me. I'm fine with that because I want to hear everything, the good, the bad, the ugly, because I'm trying to
I can go
make a decision that I think is appropriate. So if you feel like this is appropriate and you both feel like this is appropriate, then I'll go along with it. I just have certain questions. So if y'all want to, what I can do, we're getting close to 5 and the deputies need to take him back. So if y'all want, I can have this recalled tomorrow and the plea will still be here.
That's fine.
Wait, we can't request them to already pass the.
Okay. Well, we can have him by Zoom, right?
Or by tomorrow, late morning or afternoon? I mean, I may be here.
All right. Yeah, let's see.
Okay.
We'll say tomorrow, maybe by Zoom, if he can't be requested. I think it's better to do that than to rush judgment.
Yes, in, well. what's this?
All right, we'll recall tomorrow. And Ms. Efron, if you want his mother maybe by Zoom to give everybody some more insights into this, that would be great. All right. Thank you. We'll see y'all tomorrow.
Thank you,
Thanks
Judge.
for
You're
watching.
welcome.
Stick around longer and click the highlighted videos to your right. See you there.